Welcome to the Standing Committee on Health and Social Development. Today is Friday, June 19th, 2020. This is a 2 o'clock meeting, and welcome again. Just a reminder, there will be a few things that we'll go over today. For the committee members, please wait to be recognized by the chair before you begin your remarks. We're in a little bit different of a situation, so just give that an extra second. This will ensure your microphone is turned on. As discussed at yesterday's meeting, we have agreed to the following time limits with regard to presentations by departments. You'll be given a 10-minute opening statement by the department representatives, followed by 25 minutes of questions by members of the committee at 5 minutes each. There will be a 10-minute buffer at the end of the meeting, but that won't apply to this meeting. So normally, sometimes there will be other honorable members here, but they're not here today, so we'll keep the time running. Again, a reminder to speak through the chair. I want to welcome the members of the committee here. Honorable Jamie Fox, Honorable Brad Trivers, Heath McDonald, Trish Altez, and I'm your chair, Gordon McNeely. So if the agenda looks okay, and we will welcome Hannah Bell in as well today. So if the agenda looks okay, can I receive a motion to adopt the agenda? Heath McDonald has done that. So the committee will begin its considerations of Bill number 37, an act to amend the Emergency Measures Act. The committee will meet with Department of Justice today. Today we have Blair Barber and Steve Dowling representing the Department of Justice. Welcome to the committee. And then at this time, if the clerk doesn't want to say anything, we might, is there anything I'm missing, do you think?
Thanks, Mr. Chair. I think we're good for now. I can provide an update to the committee at the end of the meeting just about the public consultation piece, just to provide you with additional information.
Perfect. So at this time, I will pass it over to our guests for their 10-minute opening remarks. Thank you.
Thank you, Mr. Chair. I've been asked by Justice and Public Safety to provide information to the Standing Committee on Bill 37, an act to amend the Emergency Measures Act. As I noted during Committee of the Whole, this initiative was identified as a remedial measure to respond to difficulties caused by mandatory provisions in legislation during the COVID-19 pandemic. These difficulties were raised by departments who are working to find solutions to serve islanders. As the Minister said in Committee of the Whole, we know a second wave of COVID-19 is coming. We know that we will have restrictions, necessary changes to program and service delivery, and have to adapt the way we live again. What we don't know is the extent to which the second wave will last and the new challenges that government will face. Despite the optimistic tone we heard from members, we also don't have any certainty as to how long it might take for the Legislative Assembly to reconvene or to appropriately debate legislative changes. For instance, we know the Assembly does not currently have the ability to meet virtually in any form based on the current rules. The responsible and prudent thing to do is to identify what we expect will be needed for government to act promptly and effectively to protect islanders, but we also need to acknowledge we won't catch everything. The legislative tools we provide government to respond to the needs of islanders need to be nimble, effective, and sufficiently flexible to deal with needs we can't predict. We have had constructive dialogue with both opposition parties, and the amendments to the bill reflect their considered feedback. We have included a sunset clause, further conditions to the exercise of power, and for further clarity, a list of statutes for which the power to suspend or vary will not apply. As we noted in Committee of the Whole, there are provisions of the statute that fence in the authority of the executive branch and clarify the ultimate authority of the legislative branch to disallow an order made under the bill. Further, the powers under this bill will not be available to successive and unknown governments because of the sunset clause that has been added. We believe that these changes go a long way to address opposition concerns without depriving government of the nimble, effective, and flexible approach that is needed. Your letter of invitation asks each department to provide a response to 3 questions. How did COVID-19 impact the operations of your department? Which acts fall under your department's responsibility? And what acts should be amended to accommodate responding to a state of emergency, and in particular, what sections and why? I'll start with question 1, if that's okay, sure. Chair, and go through a number of these. With respect to question 1, we can advise the following. For the most part, the department has been able to continue to serve islanders and client departments despite reduced capacity and other operational constraints experienced in relation to COVID-19. While the courts did not close at any time during the pandemic, reductions in court operations in light of health and safety restrictions have required changes to the administrative recalculation of child support regulations under the Family Law Act to permit the suspension of requirements under those regulations to file certain information, make determinations, and schedule court dates. The department was requested to support an application to the Supreme Court respecting the enforcement of evictions arising from the operation of the Rental of Residential Property Act, as there is no option within that statute to enable government to suspend the enforcement of evictions. The regulations under the Retail Business Holidays Act had to be amended on a temporary basis to facilitate the increased demand from islanders for pickup of pre-ordered groceries on Sunday mornings in response to guidance from the CPHO to individuals to maintain appropriate social distancing. Responses to requests for information under the Freedom of Information and Protection of Privacy Act have been difficult for the government to process within the specified timelines because of the reduction in numbers of government staff available to locate, retrieve, and process records. These difficulties have been communicated to the Information and Privacy Commissioner. The department has received feedback from the Law Society and courts in relation to the operation of limitation periods. It is currently unknown if any islanders were impacted by the inability of the government to suspend or vary limitation periods. While the courts were open to file necessary court documents, individuals may have had difficulty accessing quality legal advice in a timely manner to protect their interests because of precautions lawyers had taken to comply with the directions of the CPHO. Limitation periods are contained in the Statute of Limitations, but also in numerous statutes administered by various departments. So that particular issue, I would suggest to you, applies to all departments that have statutes with limitation periods. The department administers a number of statutes with statutory timelines to do certain things within a specified period of time, including but not limited to making appeals, renewing licenses to practice certain professions and occupations, registration of personal property interests, and enforcement of liens. In most cases, these statutes do not provide flexibility for the department to suspend or vary timelines to protect the rights of islanders. These timelines have not yet, to my knowledge, caused prejudice to the interests of islanders, but we are aware that they are a potential challenge when we experience a second wave. The department also received inquiries respecting whether or not government would move to allow for virtual witnessing of wills and powers of attorney, as has been done in Ontario. In short, our Probate Act and Powers of Attorney Act will not permit such a practice. The department's Legal Services Division has also received numerous requests from client departments seeking advice on how to comply with mandatory legislative requirements and provide the most appropriate response to COVID-19 challenges. If it's all right with you, Chair, I'll move to question number 3 and then to the statutes.
Perfect, thank you.
So question number 3 is what act should be amended to accommodate responding to a state of emergency, and in particular, what sections and why? We feel that the committee's question suggests that there's a misunderstanding of the problem that this bill is intended to address. If departments knew what legislation needed to be amended in advance of an emergency, that would have been done already. This bill to amend the Emergency Measures Act is intended to temporarily address those legislative issues that we have just recently identified and issues that have yet to be identified. The types of changes that we may need to make to accommodate government action in a state of emergency are well summarized in subsection 11.2, sub 1.1 of the bill as amended by the Leader of the Opposition's motion. These include laws that govern services, benefits, or compensation, laws that establish a limitation period or a period of time for commencing or taking a step in a proceeding, including court actions, appeals, and other types of proceedings. Laws that establish a requirement for government or a person to do, obtain, or provide anything within a specified period of time. Laws that require the government, a corporation, or municipality to do, obtain, or provide anything within a specified period of time, or to hold a meeting or public meeting. And laws that establish the form or manner in which anything is to be done. It's important to note it's not enough to identify a statute or provision of a statute that may need to be made to accommodate government action. It's also necessary to conduct the proper research, consultation, and expert review to ensure that the change is both necessary and appropriate in the circumstances. Without advanced knowledge of the circumstances, our department and government will face the next wave of without advanced knowledge of the circumstances that our government will face in the next wave of the COVID-19 pandemic, it can be difficult to determine in advance what needs to be changed and identify what the appropriate remedy is to accommodate the emergency. And finally, if I was forced to give an answer, what act should be amended to accommodate responding to the state of emergency? It is, in fact, the Emergency Measures Act, and we feel that the bill is an appropriate amendment to allow us to deal with those emergencies. I'd like to move to our statutes. Our department administers approximately 140 statutes. We'd like to provide you with an overview of those statutes and some high-level commentary on the types of provisions that may need to be changed to accommodate an emergency, just to give you an idea of where these things are located and the practical difficulty we have in foreseeing and responding without knowing all the facts on the ground. Please note my comments should not be taken as an indication that change to these statutes is necessary or appropriate. I'm simply highlighting some of the types of provisions that are contained in our statutes. So to begin with, the Affidavits Act. The requirement to swear an affidavit before a commissioner for oaths requires the oath to be taken in person. This requirement could be varied to provide direction on how an affidavit could be sworn without contravening any applicable public health restrictions. We have the Age Majority Act, the Ancient Burial Grounds Act, the Appeals Act, the Apportionment Act, the Arbitration Act, the Auctioneers Act. This particular act provides for a license to conduct auction sales and expires 2 years after issuance. The requirement could be varied, for instance, to extend licenses for a period while government operations are restricted. We have the Blind Workers' Compensation Act, the Business Corporations Act. As I noted in Committee of the Whole, JPS received feedback that there's a mechanism needed to expressly allow for virtual corporate meetings where the corporation has not previously made bylaws to permit virtual meetings. The Business Practices Act. The Act provides a timeline for when notice to rescind a contract must be claimed after an agreement is entered into. We could look at varying this requirement perhaps to extend the timeline depending on the circumstances. The Canada-United Kingdom Judgments Recognition Act, Canadian Judgments Enforcement Act, the Cannabis Control Act, the Cemeteries Act, the Change of Name Act. This act provides for an appeal of the Director of Vital Statistics decision within 30 days. You can imagine in a state of emergency where we have restricted operation, that might be difficult. So this requirement, we could look at suspending that for the period of the state of emergency or varying that requirement. The Charities Act, the Chartered Professional Accountants and Public Accounting Act. Again, this act provides for a 30-day appeal period. The time period could be suspended or varied during a state of emergency, depending on the facts on the ground. The Child Status Act. This act provides for a public right to inspect documents maintained by the Director of Vital Stats. This right could be suspended or varied during the state of emergency, if appropriate, to comply with any restrictions imposed by the CPHO. The Cooperative Associations Act, same comments that I had for the Business Corporations Act would apply here. The Collection Agencies Act. This act contains enforcement provisions about inspections by government. We'll see these in other department legislation as well. They may need to be varied during a state of emergency to align with CPHO restrictions. Specifically, one of the powers we have is entering into the premises of a licensee and inspection of records. The Common Business Identifier Act, the Comerientes Act, the Companies Act, similar comments to what we had for virtual meetings under the Business Corporations Act, the Consumer Protection Act, the Consumer Reporting Act. This act requires a license to operate a consumer reporting agency that expires 2 years after issuance. Again, because it's a licensing issue, we might look to have the power to extend the period of the licensure during a state of emergency where we have restricted operations. The Contributory Negligence Act, the Controverted Elections Provincial Act, the Coroners Act, the Correctional Services Act, the Court Fees Act, the Court Reporters Act, the Court Security Act, the Credit Unions Act, similar comments about virtual meetings, the Crown Proceedings Act, the Custody Jurisdiction and Enforcement Act, the Defamation Act, the Dependents of a Deceased Person Relief Act, the Designation of Beneficiaries under Benefit Plans Act, Direct Sellers Act. This particular statute also requires a license to be able to engage in direct sales. We may look to any appropriate circumstances to extend the period of licensure. This act also provides for an appeal period, which we might want or need to extend in the event of a state of emergency. The Electoral System Referendum Act, the Electronic Commerce Act, the Electronic Evidence Act, the Emergency 911 Act, the Emergency Measures Act, the Escheats Act, the Evidence Act. On this particular item, I can advise that the federal government, I believe, is looking at the rules of evidence in the context of criminal matters, and we might look to adopt the same innovations that they are looking at adopting in terms of the receipt of evidence during a trial. Extra-Provincial Corporations Registration Act, Factors Act, Family Law Act, the Fatal Accidents Act, the Films Act, the Fire Prevention Act. We have a provision in this particular act that requires public meetings to establish a fire district. Of course, public meetings can be difficult to put together when we have CPHO restrictions. The Firefighters Long Service Medal Act, the Floral Hills Memorial Gardens Administration Act, the Foreign Resident Corporations Act, the Franchises Act, the Frauds on Creditors Act, the Freedom of Information and Protection of Privacy Act. In this particular statute, we have time periods where government is required to respond to requests for information within a certain amount of time. We also have appeal mechanisms. Both of these could be looked at. Frustrated Contracts Act, Funeral Services and Professions Act. This has a licensing provision and an appeal provision. Again, those would be something we would look at to suspend or vary. The Garage Keepers Lien Act. This particular act and other lien legislation includes certain time periods for holdbacks and also for when an action must be commenced to recover, I believe, from the lien. So those are things we might look at. Garnishee Act, the Gift Cards Act, the Habeas Corpus Act, the Human Rights Act. I understand that there are time periods in that statute that might also be appropriate to suspend or vary during restrictions. Insurance Act, the Interjurisdictional Support Orders Act, the International Commercial Arbitration Act, the International Sale of Goods Act, the International Trusts Act, the Interpretation Act, the Interprovincial Subpoena Act, the Investigation of Titles Act, the Islander Day Act, Judgment and Execution Act, the Judicature Act, the Judicial Review Act, the Jury Act, the Justice of the Peace Act, the Landlord and Tenant Act, the Legal Profession Act, the Limited Partnerships Act, the Lobbyist Registration Act, the Maintenance Enforcement Act, the Marriage Act. Believe it or not, there's a licensing provision here for commissioners that we could look at extending potentially. The Mechanics Lien Act, we talked about liens. The North American Labor Cooperation Agreement Implementation Act, the Occupiers Liability Act, the Partnership Act, the Pay Equity Act, the Payday Loans Act. This particular piece has licensing and appeal provisions as well. The Perpetuities Act, the Personal Property Security Act. This is a very complex piece of legislation that has numerous time periods in it that we would want to, in a state of emergency, look at and consider whether or not we need to change, but we'd also have to be conscious of what is going on in our other Canadian jurisdictions. The Police Act has appeal provisions. We would look at that. The Powers of Attorney Act, we talked about this. This is the form and manner of execution of powers of attorney. The Prearranged Funeral Services Act, the Premium Tax Act, the Private Investigators and Security Guards Act. This has licensing and appeal provisions. The Probate Act, we discussed this in Committee of the Whole, the form and manner of executing a will, including the in-presence witnessing of the execution of the will. The Probation Act, the Provincial Administrator of Estates Act, the Provincial Court Act, the Public Trustee Act, the Quieting Titles Act, the Real Estate Trading Act. This has licensing and appeal provisions. The Real Property Act, the Reciprocal Enforcement of Judgments Act, the Regulations Revision Act, the Retail Business Holidays Act, the Rural Community Fire Companies Act, the Sale of Goods Act, the Securities Act. This has licensing and appeal provisions. It also has certain time periods in it that we might look at. Securities Transfer Act, Sheriff's Act, Statute of Frauds, Statute of Limitations. I believe I mentioned this in Committee of the Whole. This deals with limitation periods in civil matters. Summary Proceedings Act, the Survival of Actions Act, the Time Uniformity Act, the Tobacco Damages and Healthcare Costs Recovery Act, the Transboundary Pollution Reciprocal Access Act, the Trespass to Property Act, the Trust and Fiduciary Companies Act, the Trustee Act, Unclaimed Articles Act, the Unconscionable Transactions Relief Act, the Variation of Trusts Act, the Vendors and Purchasers Act, the Victims of Crime Act, the Victims of Family Violence Act, the Vital Statistics Act. We had discussed this briefly in Committee of the Whole in the sense of the death certificates and who signs them, but there's also access to vital statistics records, form and manner requirements in terms of filing things, and time periods there that in the appropriate circumstances we would look at. Volunteers Liability Act, the Warehouseman's Lien Act, we talked about liens, the Winding Up Act, and the Youth Justice Act. To conclude, and thank you for your patience, Chair, the emergency powers outlined here are not supposed to be our first recourse. These are measures of last resort. They are, first of all, intended to support the experts to protect the health and safety of Islanders. They are also to ensure Islanders can continue to access government programs and services with as little disruption or impact as possible. While it is true that we have been able to pivot and continue services, we cannot fully know what the second wave will look like or how it will impact our department or the government as a whole. Thank you, Mr. Chair.
Thank you very much. Great. Thank you for that presentation. And at this time, we'll open it up for to the members for questions. Did you want to add anything to that before we do that, or?
No, that's a very fulsome introduction and presentation.
Perfect. Okay. We'll start with Jamie Fox.
Thank you, Chair. I only have a couple questions, and thanks very much for coming in. The first question is, the changes of what we are talking about for the EMO Act, these are limited, I shouldn't say limited, these are limited in time for how long they are in place. Could you please explain that to the committee?
Yes.
Thank you, Mr. Chair. That's correct. The Act's provisions are in place for a limited time. As we discussed at Committee of the Whole, the emergency power can only be exercised upon the declaration of a state of emergency by the minister. The Cabinet has to be satisfied it's in the public interest, and it can only be used for certain purposes. It is also for a limited duration. It can only last 90 days. That 90 days has to be within the state of emergency or the 90 days following the state of emergency. Thank you, Mr. Chair.
Thank you. Jamie Fox.
Thanks, Chair. And the second question I have is during what we've witnessed and been through in the last, I think it's over 100 and some days now, 3 months plus, if this change to the EMO Act would have been in place, would it made dealing with COVID-19 and what the province has been dealt easier?
Thank you, Chair. That's an interesting question. Judging by the response I had from our legal services solicitors, telling me about the number of clients that were contacting them to find workarounds, I would think absolutely yes. These changes would have made it a more simple process, I think, for them to find a workaround the restrictions that were in place from the CPHO. I don't have the specific information, of course, member, because those particular communications would be subject to solicitor-client privilege. I'm only aware of a few of the items that we discussed in Committee of the Whole that we discussed at that time.
Mm-hmm. Okay, thank you.
That's good for Mr. Fox. Trish Altes?
Yes, thank you, Chair. So yeah, I do have a few questions. So would any orders in council made under this legislation be subject to a judicial review? Is that something that would be possible?
Absolutely.
Okay, so how would that process work?
Trish Altes?
Oh, sorry. How would that process work?
So from the moment the order in council is issued, it is typically published. Orders are published in the Royal Gazette. They're also published online. If a member of the public felt themselves affected by the order, that their rights had been violated or that the Cabinet had overreached its jurisdiction under the Act, then they could make an application to the court for a declaration from the court to that effect, that the order would be of an overreach or of no effect because it's outside the jurisdiction of Cabinet.
Okay.
Trish Altes?
Thank you, Chair. So in that case then, would the courts and then by extension the public have access to Cabinet documents that were used to inform decisions in that whatever the situation is, the particular example?
Yep, go ahead, Blair.
All cabinet conversations, all cabinet dialogue is subject to cabinet confidentiality. The order in council would be, and I discussed this in Committee of the Whole, the order in council would simply provide that the order was made pursuant to the section of the Emergency Measures Act, what the order was meant to do. So if it was to suspend or vary a provision of an act, it would provide for how long the order is in place, and it would provide if there was a provision for the alternate. If you're varying a requirement, it would set out what the varied requirement is. There are examples, if you look to other jurisdictions that have similar powers, Alberta, Ontario, where they have published these, they're online on their e-laws websites. In our own context, we do have statutes in Prince Edward Island where Cabinet issues orders under that legislation, and they are published in the same manner and look the same as a regulation might, or very similar.
Trish Altes?
Okay. So I'm trying to understand the process then, just what the recourse would actually be in that case then if the information wasn't made public about that inform the review, I guess. It just seems like a bit of a snag in what is the usual process in that sort of situation.
I would suggest to you that's not the case,
Okay.
but if there was an application for a declaratory order, the government would obviously be a party to that application, and the government would be provided to bring forward evidence to support the exercise of their authority. It would not necessarily be, though, those records that are subject to Cabinet confidence.
Trish Altes?
Thank you, Chair. Okay, so then Cabinet could be selective in what information it is bringing forward, I guess, in that case.
Yep.
No, Cabinet always has the discretion on what records that are subject to Cabinet confidence that it wants to release. But for the purposes of the court application, the court has to be satisfied that there are facts sufficient to justify the exercise of discretion. So the government would be required to prove their case that the order was actually made within the jurisdiction of the Emergency Measures Act and would have to provide evidence sufficient to satisfy the court.
Okay.
Trish Altes?
Thanks, Chair. Different question. Can you just walk us through the legislative drafting process for this bill?
Certainly.
Thank you, yeah.
So what we do with any bill, and if I'm missing a step, please let me know. We identify internally whether or not there's a need for legislation, what is the issue we need to address, and then we look at options to address it. We consult with legal counsel, legislative counsel, we discuss it with operational staff, depending on what the subject matter of it is. We submit a legislative proposal to Cabinet for Cabinet's consideration. If Cabinet approves of the legislative proposal, we have drafting instructions that we submit to the Legislative Council office. Once that bill has been drafted, we sometimes do out with a consultation draft, as has been done with the various caucuses, and we consult on that particular draft to see if there's any feedback before we finalize it. When we have what we think is a final draft, we provide that to Cabinet for approval to print, and we bring it forward. In a nutshell, that's the procedural piece.
Okay.
Trish Altes?
Just one follow-up question to that. So that was kind of a general overview of how, bills are drafted. Was there anything, different about this process at all, or any particular consultations that?
Not particularly in the sense of the actions that we were required to undertake. I think there was a sensitivity at the time that COVID-19 was occurring, that there were restrictions, and departments were urged to identify what are those items that you think are necessary to bring forward to better help us provide services to islanders and address some of the statutory limitations that we're facing.
Okay.
Trish Altes?
Yeah, thank you, Chair. So I don't know, I sort of felt during the debate that some of the time the terms suspend or vary, there seemed to be a little bit of confusion about those two terms, and maybe you could just explain to me what would go into a decision to suspend or vary an enactment and explain the sort of different options there.
Sure. And if you don't mind, I'll use Ontario as an example. Ontario suspended certain limitation periods during the pandemic, if I'm recalling correctly, and they provided that the limitation period would start so many days after the state of public health emergency. I think that's how they set it up. So a suspension would be just to say stop the clock on a particular timeline, and that, I think that reflects, as we discussed earlier, the need to ensure that people have the right or have the ability to access quality legal advice to protect their rights. Also, if people are going to have difficulty filing process, that would be a useful thing to use. When we're talking about varying, we're looking at, it's usually the easiest thing to point to would be a procedural requirement. And so what you're doing is trying to provide an alternative to meeting that procedural requirement. So for instance, if we're looking at the requirement for meetings to take place, we could vary the requirement. If it required it to take place physically somewhere, we would be able to say vary it and allow for a virtual meeting or some other arrangement.
Trish
I
Altes?
think I've probably used the most of my time, so I will give over the floor to someone else, and if there's more time, I might have more questions. Thank you.
Thank you. Hannah Bell?
Thank you, Chair. One of the things that we also asked questions around, I'd like to follow up on, was about the definition of public interest. I was wondering if you could define public interest for the committee, please?
Sure, and you know, when we were developing the bill, we saw this in Alberta, I think it was in Alberta, and they don't define it in their statutes. And so the general rule of statutory interpretation is that when you don't have a defined term in the statute, you look to the common or general meaning. In my particular case, I'm a lawyer by training, so I looked at Black's Law Dictionary to see what they suggest. And what that is, it's for the public interest versus for a private interest. So you look at the general public welfare versus the individual welfare of private parties. And I appreciate that's rather imprecise, but that's how the Black's Law Dictionary really looks at defining it.
Annabelle?
Thank you. Yeah, and I appreciate that. I guess that's partly why there's a challenge here, because obviously, the determination without some kind of guidelines around that, there's a risk. We feel a significant risk that is ultimately a subjective decision. Looking at sort of other law and guidelines that have been used to determine anything that impacts rights and freedoms, is that there should be some reasonable limits, and there's usually some kind of definition, or hopefully a definition about what parameters you put around that. Look at the Charter of Rights and Freedoms, and those parameters include having an objective, being necessary, being proportionate, being time limited. Mm-hmm. So in the definition of public interest here, have any of those elements been considered when you are determining if something is in the public interest? Because obviously we went through a long list of statutes in there, and I would argue that there's some of those in there that don't necessarily meet the same level of if we applied some parameters.
And I think we would need to look at the particulars. The courts in various cases have defined public interest in various contexts. We would certainly see the public interest as being about benefiting the public welfare as a whole. And I appreciate this can be a little bit of a smell test when we're looking at it because it's imprecise. Mm. But versus particular exercise of the power to benefit particular persons, corporations, that sort of thing. I know, I appreciate that's still imprecise. I would say, though, you mentioned the grounds, the fencing in the charter. If you read the case law, you would also see that's also very imprecise. Mm-hmm. And the courts, through their jurisprudence, find a way to better define it depending on those circumstances.
Annabelle?
Thank you. Yeah, and I unfortunately don't have the time to do that too, but which is why we have people like you, Blair. But appreciate, though, I think you can appreciate the discomfort that brings for legislators and for members of the public who see that the public interest would be interpreted in different ways by different people, and that's one of the challenges that we've had with legislation that outlives the current administration, is that when we make these changes, we're making these not just for our current space, but for a future space. For example, we've seen out west or in the US, where governments have reduced environmental or public health standards under it being in the public interest because it was more important to restart the economy than it was to actually save people's lives. I know that's an extreme example, but it is a tangible, real one that we can see where public interest is not being defined within a set of parameters that have at least some context to protecting the rights of the individual. And so, I would be hopeful that we would consider that is one of the reasons why, that having that broad definition, though I understand the case law process for it, yeah, creates a real problem from a legislative perspective. Moving on from that, I just wanted to say, what jurisdictions, you've mentioned Ontario and Alberta, what other jurisdictions have you looked at when you were preparing this legislation?
We looked at a number of jurisdictions. Just 1 second. We looked, so in terms of the jurisdictions that have some ability to do a statutory override type thing where there's an express provision that allows you to affect existing legislative requirements. We looked at Alberta's Public Health Act, which is actually quite broad. It's more broad than what we are proposing, and certainly more broad than the amended form of the bill that we're looking at. We looked at Ontario's Emergency Management and Civil Protection Act. We did note, too, that Yukon's Civil Emergency Measures Act has a notwithstanding clause attached to their general authority, which is an interesting way of doing things, but certainly not as transparent as what we are proposing.
Yeah, let's not do that.
We looked, New Brunswick did this year. I appreciate they just withdrew a bill, but previous this year, the Emergency Measures Act there provided for the variation of timelines and statutory time periods. I believe Newfoundland passed the Temporary Variation of Statutory Deadlines Act as well. And my correspondence with my colleagues across the country indicates that the Northwest Territories just amended its legislation as well. And I believe that was only in response to statutory timelines and time periods.
Thank you for that clarification. Chair, if I can just
Hannah
have one more question. Or it's, we had mentioned earlier about the fact that because the legislature isn't able to sit, that this is one of the challenges here is in the event that the legislature isn't able to sit. And I know you're aware that there is a motion that has been brought forward. So my other hat is as the chair of the Rules Committee, and I was not contacted by your department or in that capacity. I don't know if the clerk was, but it would have been referred to Rules even if the clerk had been contacted, because it has to go through Rules to change. And obviously we are going to be considering it, but you know, sort of when that is on the table, you know, was there any discussion at any point about that being a priority or being made more of a priority to try and to bring that forward as another option rather than taking this route?
In the circles I was working in within our department, what we determined was, in order to be responsible and prudent with this particular piece, we have to assume the worst case scenario. We don't know what we don't know. We don't know what's going to occur. We could have a state of emergency where there's no power, there's no internet connectivity. I'm thinking if we had a hurricane on top of a pandemic, on top of whatever else. We know, and I believe it was in BC earlier this year, we had times when we had protesters that were blocking access to the legislature for members of the Assembly. So we wanted to make sure that there was always a means to address an emergency, and hoping absolutely that the Legislative Assembly can meet when it has to. But we have to be prepared for the eventuality that it can't. I think the amendments that were made to the bill also reinforce that fact too, the fact that the Assembly can disallow an order by resolution. I think that also indicates our preference that if there's a legislative change that needs to be made, that the Legislative Assembly is the first choice if we can reasonably do so. But we need a mechanism if we can't do so. Thank you, Chair.
Thank you very much.
Thank you, Chair.
Great. I'll move to Heath McDonald.
Blair, just, is there any way to circumvent the issue of giving the broad powers to Cabinet, that they don't have to, you know, dispose of some of the information when they walk out that door based on the decisions that they've made? Is there any way to do that?
You mean as an alternative to the approach that we have here? The problem we have is we don't have a crystal ball to know what's going to impact us. So it makes it very difficult for us to craft a more precise authority to address emergencies that may arise. And each emergency will be different. Even each wave of a pandemic could be different. Some jurisdictions that have different statute books and different flexibility in individual statutes have decided just to deal with the timelines and statutory periods. We discussed that. But from what I've seen in the different jurisdictions, we discussed this, Ontario and Alberta have the express provisions to suspend or vary. Yukon has a notwithstanding clause, which again is not incredibly transparent. We have the jurisdictions that have dealt with timelines. And then we have other jurisdictions that are trying to find workarounds within existing legislation without making specific changes.
Heath McDonald?
So timelines is essentially the important matter that we're dealing with, to make those decisions quickly as possible.
It's one of the issues.
So when you
Heath
talked,
McDonald?
you talked earlier about when executive council comes out with a law or within the emergency measures timeframe, and you talked about ensuring that it would be specifically evaluated towards the laws that are in place. But if it's not, how long does that take through the courts to have that rectified or looked at during the middle of a pandemic? I guess that's where I kind of get lost, saying if we're dealing with timelines and something doesn't look right or pass the smell test, as I think you said earlier, then how is that evaluated that quickly?
What we do know, and I referenced this in my comments, is that when we had the issue of enforcement of residential evictions, we made the court application late one week and it was heard early the next. So the court is open to hear applications on an urgent basis, and I'm fully confident that if there was an allegation that Cabinet was offside its powers under emergency measures legislation, that they would look at that very promptly.
Mr. Chair, I could add that the court, as Blair has expressed, the court has inherent jurisdiction to grant injunctive relief, which can either be preventative or actually prescriptive. And from my perspective, in legal practice, is that they can be even much more responsive than in a week, depending on the urgency of the circumstances. They are prepared to act in whatever timeline is necessary. What one keeps in mind, though, is that when one is seeking injunctive relief, in one sense, the onus reverses to those seeking injunctive relief to prove, sometimes after the fact, that the basis for which they sought this interim order was justified. And so that's also an important check and balance that the courts can play, such that if someone is bringing an application for injunctive relief, then they also have to prove to the court, often at a later date, that there was merit to their concerns. So in terms of timeliness of being able to do that, from my perspective and my experience, the judicial branch is very, very responsive, basically, to meet any timeline that the public interest demands.
Excellent.
Just one quick one, Chair.
Heath McDonald?
What's the penalties or what's the outcome if the courts find that executive council has broken the legislative
Steve
process or response, I guess?
Steve might add to my response here, but generally speaking, you would apply for a declaration that government is offside, and that would be the extent. There are circumstances, though, I believe, where the court has authority to issue other remedies.
Yes, I would agree. That's what one would expect. Is you have a if one thinks of constitutional matters or a constitutional challenge, you may have a declaratory decision to bring the matter back to the legislature for reconsideration, or basically striking down a particular decision by government, which forces government then to start the process anew. But the general practice would be declarative rather than getting into the realm of damages or anything like that. That's usually the realm of civil realm.
So
Heath McDonald?
So first of all, let me be clear here. So it could be challenged in the courts first,
Correct.
or it could come back to the Legislative Assembly.
I mean, if a matter were challenged in the courts, and the courts, for example, struck down, any government decision, then the jurisdiction is then still available for the legislature or for government to exercise, its powers to perhaps, make a different type of decision with the guidance from the court. But essentially, if there were a declarative decision to let's say, strike down a particular decision on a piece of a government decision based on legislation, then that's the end of it. That particular decision is struck down, and then the legislative branch, executive branch, still has their jurisdiction to continue on with their work.
Heath McDonald?
So from a layman, I'm looking at it two ways. I'm looking at it could stay in the courts for quite some time, or if it comes back to the Legislative Assembly and we don't have a minority government, it's done.
I wouldn't agree with that conclusion.
That's my layman term.
And I appreciate that. I think, though, the court would issue a decision, and if the government was found to be offside, then you have your result. And if government didn't agree with that decision, it could revisit how it made the order. It could decide not to issue another order. It could appeal the decision, but the court's decision would be in place until the appeal court dealt with it. So the only time when you're really running into an issue, I think, is if the applicant loses the case and they want to appeal it, and then how quickly will the Court of Appeal deal with the issue? I couldn't, with confidence, tell you.
Sure.
Thank you.
Thank you, Heath. Brad Trivers?
Okay, thanks, Chair. So my question's just getting back to, the base, just clarifying a couple of things. So you talked about a lot of statutes in your opening presentation. Just so how many acts actually do fall under your department's area of responsibility in total, and how many acts had you listed that would need to be amended if you counted them up? Just to give a summary picture in our minds of what we're talking about here. I know you read them out, but if we counted them all up, what would the numbers be?
It's approximately 140. And I take your point, how many would we think might need to be amended? And I guess the answer to that is, it depends, which I appreciate is an unsatisfactory answer if you're looking for some certainty. I did do some brief searches on databases to try to line up what we were looking at government-wide relative to certain criteria that are included in the subsection that I described before. And so when we looked at the words limitation period and day, I came up with 48 acts. We have more if we have limitation period in year. I looked at appeal and board and day. I found 79 acts. Timing requirements are all over the place in our statutes. It's really difficult for me in the time we had to go through them and identify all the potential changes we need to make if the circumstances make it impossible to comply with both the statute and restrictions that we have. I looked at public meeting. I found 6 references to public meeting government-wide. Of course, public meetings are a particular issue of concern because it's not just about saying you can have a virtual meeting. You have to provide for all the other aspects that are important to public meetings, and how do you capture those in legislation so you still have effective public participation and you have effective records of what was said and the number of people who voted for or against a particular matter. So I apologize, I'm not able to provide a more precise answer, but the nature of the issue is until we know what the emergency is, we don't know what until we know what the emergency is and the associated restrictions, we don't know how many statutes will need to be amended or varied or suspended to deal with the particular issue.
Brad Trivers?
And thank you, and I appreciate that. And in fact, that was one of the concerns that I raised in our last committee meeting before this one, when we were engaging departments to try and determine and ask them that question, how many acts should be amended to accommodate responding to a state of emergency, in particular what sections and why. I was concerned about the amount of time it would take for departments to be able to figure that out, the lack of information required to do that, because depending on the emergency, it means different things, and the scenarios are always different. Like you had mentioned, multiple emergencies happening at the same time. Now, so we are, Chair, currently in a pandemic and a state of emergency, and presumably we had a emergency sitting at the legislature because we needed to have these powers in case we needed to continue to govern in this state of emergency. And I remember very clearly that this committee had a similar debate when we were talking about Dorian. And I remember, Chair, we were waiting for the report back from the minister, and the arguments that everyone here at this committee was trying to make on the opposition side was that we need to know right now, because what happens if there's another Dorian comes along? I remember those arguments.
I made that one too.
You did that one. You made that one as well. That's
I
right,
could
Chair.
argue back against that.
And the thing is, we are actually in a state of emergency and in a real pandemic right now. And we need this ability to deal with it. That was a hypothetical situation before. You guys were actually arguing the opposite side. So I don't know. It seems to me that we need to move forward on this. We need to get through these committee meetings, and we need to make changes to the Emergency Measures Act so that we can deal with unknown scenarios. So I just wanted to make that point. I'm not sure if I have a question per se, other than maybe, do you foresee, as we are in a pandemic and a state of emergency, that limitations are actually looming on the horizon that could cause us to not be able to make the decisions we need to make to protect the people of Prince Edward Island?
I'll say this, from where I sit in government, it's very hard for me to know the operational reality in all the different corners of our operations. As I noted in our comments, Justice and Public Safety has, for the most part, been able to continue operations despite the restrictions. Perhaps Steve might be able to comment on some of the issues with respect to his division.
Yes, Mr. Chair,
Sure.
if I may, perhaps a useful practical example to your question would be with respect to our credit union system. So early in the state of emergency, we were contacted by representatives of the system, directors and managers of local credit unions, who raised the issue of their legislative requirement to hold an annual meeting within a fairly short period of time after their year end, which is often December 31st. And so they were in March, they were facing an imminent deadline to meet an annual meeting requirement. And the reason that example jumps out at me as particularly poignant is that, as many people can attest, our local credit unions, their annual meeting process, it's very important. It's very important for members of the community. Often there are hundreds of people that traditionally come out to annual meetings, and it's their opportunity to exercise their rights as members of the credit unions. So what we were asked was two questions. What flexibility does government have to offer some type of ability to delay the annual meetings? And also, what type of flexibility is there to have virtual meetings rather than the in-person meetings? And you could tell that the questions were quite earnest, because the system is very aware of the requirement to have not only to have an annual meeting, but one that is considered to be meaningful and properly run by their members. What we were able to do in that circumstance, we were able to, through the legislation that we have, we're able to invite them to make a request for an extension in writing, And it's the first time we've done this in this particular manner, but the circumstances warranted that in reference to the pandemic, we allowed all of our credit unions to delay their annual meetings up till December of 2020.
There you go.
The way we did that, the reason we did that was to allow the maximum amount of time available under the legislation to be able to get them the flexibility to see what happens in the future. Now, the second part of the question was more difficult. Can we allow them to have virtual meetings? The answer was we're directed by the legislation, and the legislation is fairly specific in that they have to be at a particular time and place, and it does not allow them to do that. So the only answer we could offer at the time, very early in the pandemic, was that government's aware of those concerns and is working on a solution. And so now we're in the situation where we're expecting a second wave of the pandemic. We also, one can think of various scenarios where other natural disasters or what have you could cause other disruptions. And so there's a time clock running. So the credit unions may be able to have meetings. They given the attendance at meetings these days, we're still not in a period where they could do that. These are very, very large group meetings. So they are still looking for a legislative remedy. And they know that if they acted unilaterally to hold a meeting virtually, they're at risk of compromising the rights of Islanders and members. And so they're actually looking for a remedy to honor what's traditionally referred to as the minority rights of individual membership or shareholders in a for-profit company setting. So they're still looking, they still need that answer. So we've given them some time with the legislative tools we have, but what we're not able to do operationally on the ground, if you will, is offer them that legal certainty. And that's really what they're after, and that's what they still need. Will they be able to, hold annual meetings sometime later in the fall? Will it be okay? It's possible, but they've asked us to fix it in, as early as this past March, and they're still, that's what they expect is that I'll do my best to help them out, and that government is on the issue.
Perfect. Okay. Thank you. Trish Altas?
Thank you, Chair. So I'll just start by providing a little clarity to the Minister about my position around Hurricane Dorian, because it is relevant to the questions I'm going to ask. That was for us to learn from what we already knew from the experience of Hurricane Dorian should another similar situation occur. Right now, we are in COVID-19. We are waiting or anticipating a second wave. So this is about how do we prepare for COVID-19 and what that might bring forward in the future. I think that the argument that we have COVID-19 and any other number of things can happen is a bit of a stretch, but I want to just add, I want to come back to something that my colleague Hannah had mentioned around the requesting some consultation from the Rules Committee about virtual meetings of the Legislative Assembly. So because the real crux of this whole thing, and as far as I can tell, is that if the Legislative Assembly can't meet because of the COVID-19 crisis and can't, pass legislation, as things come up, then we're going to need to give these, special powers over to Cabinet to be able to do that quickly and efficiently. However, if we can have virtual meetings, just like, the House of Commons and other jurisdictions across the country are doing, then there's no real reason to do this, because the Legislative Assembly would then be able to meet no matter what. And I would, think that we would all be very willing. I know that other people in the legislature have talked about all the measures they would be willing to go to, such as wearing a mask, or we can also go down to 10 quorum in the Legislative Assembly. But if none of those things would be possible, because what's happening with COVID-19 is so severe, then the virtual option is always on the table. So I guess I'd just like some clarity on was that considered, the reality that is sort of circumvents the need for this?
Just a second, Chair. Was that an intervention?
Yeah.
An intervention by Jamie Foxx?
Thanks, Chair. I want to pick up on what Mr. Downing said. A prime example of an act that worked good during COVID-19 was the Municipal Governments Act. I could, it falls back to what you were saying about the credit union. Under the Municipal Governments Act, municipalities in this island have a very strict set of rules they have to follow to provide proper governance to the province. The department saw what the problems were going to be with COVID-19 in what they are required to do under Municipal Governments Act. And I was able to suspend timelines and give them the opportunity to put off legislative requirements until they could actually do them safely. And that's a prime example where that act was prepared for what could happen. Now, of course, when things get back to normal, I can put things back in place, or I can give them a new timeline to make sure that they comply with the act. But that's a prime example. If we had to do that for 148 acts, or however many, to change it to give them, I don't know how we'd ever get them done. You know, if you look at what the normal sitting of the House has, you know, we get through acts on a priority of medium, high, and low levels, and we try to deal with them. But I think that it's to be able to deal with reality in a very time-sensitive measure or manner to make sure that we protect life and property as needed to protect our citizens. So a minute ago you said a stretch of the imagination. I'd like you to define what a stretch of the imagination. If COVID-19 would have happened in the wintertime and we have an ice storm or we have a Dorian, then at the exact same time, I think we need to make sure we're prepared for that. Because I can tell you, and I said it in this House, there's nothing worse for a first responder or a member of the Public Service Commission to have to deal with something and they can't deal with it at the time. The mental strain that puts on a first responder or a Public Service Commission individual is phenomenal. And we must remember that. We're not only protecting the citizens and their rights, and I'm a person that strongly believes in the Constitution and how we are to protect our rights as citizens, but we also almost think of the Public Service Commission and what they have to deal with on a daily basis during a pandemic or during an emergency. So like, if you could explain, Honourable Member, what you mean by stretch of the imagination, I'm very interested in that.
I'll bring it back to Trish.
Thank you.
Do you want the floor, or would you like the guest to answer your original question, or?
Thank you, Chair. I appreciate that.
Whatever you want to do.
Yeah, no, I will just respond quickly to that. Members have asked throughout the original debate as well as now in this process, you know, to have some clarity on what acts might need to be suspended or varied based on what we've learned so far about COVID-19, and there hasn't been a lot of clarity provided for that, and I've definitely not heard an argument that 104 acts would need to be changed immediately based on what we've learned. So I think sticking to the point at hand is that we are preparing for COVID-19, and going back to the question, so about virtual sittings of the legislature, was that something that you considered?
We certainly considered what obstacles might there be to the Legislative Assembly meeting. And when it comes down to it, we have to prepare for the eventuality that, simply put, the legislature cannot meet. Full stop. We can go into all sorts of different circumstances that might cause that to happen, but we need to have a mechanism in place that allows us to suspend or vary legislation promptly, as the minister said. We absolutely need time, obviously, to prepare the amendments that might be needed to come to the House. But we have to have an ability to deal with a matter if the Legislative Assembly is not able to meet on the issue promptly to examine and debate on bills.
Perfect. Trish Altes, sorry.
Thank you, Chair, sorry. Just a different line of questions that I would still like some clarification on. So what would the process be then? A department identifies that an act or several need to be changed, suspended or varied. Can you tell me then what that process looks like?
I think I did earlier.
Yeah.
There's
So,
a
the
process.
executive council memo, sorry, more specifically.
So
what
the
would that look
executive
like?
council memo, there is a template, a legislative proposal is what we would be looking at for a bill. If we're looking for an order, it would come forward with an executive council memo, which is simply a memorandum. It is subject to cabinet confidence, and it does go to cabinet and it explains the rationale for the bill and the background that leads to the proposal for the order to be made in that particular case. In the case of a bill, it's a legislative proposal, as I discussed before.
Treasurer.
And so you also, I believe, mentioned the requirement or that you might consult with experts or stakeholders, and is that a requirement, or is that just a sort of a recommendation?
I think it depends on what the situation is. If we were going to look at suspending or varying, if we were looking to suspend or vary a provision, for instance, that dealt with the administration of justice, we would absolutely consult with the courts. The courts, of course, are masters of their own branch, and we would want to make sure that anything we did was on side with what the courts thought was appropriate and what was necessary in the circumstances. If we were looking at the example that Steve mentioned of the credit unions piece, we would consult with the credit unions, but it's a small amount. That would be a small suspension or variation, so that the consultation would not necessarily need to be broad. So it really depends on what you're looking at. In terms of the experts, it would depend on the issue. If we were looking at an issue that potentially impacted the rights of people, we would go for a more rigorous legal opinion. If it were a simple procedural matter like Steve raised, we probably wouldn't need a rigorous legal opinion on that particular matter because the issue is the specific wording in the statute.
And if I may, Mr. Chair, I could add, as a practical observation, whether it's the credit union example or quite frankly, just days ago, we had one of a number of requests just came in days ago from a not-for-profit corporation, essentially looking for the same remedy. Is there any way you could be flexible and allow us to have electronic meetings, which currently there's a specific requirement to have them at a time and place. If, as I alluded to, in the current circumstances as a public servant, the only proper answer I can give is that folks have to abide by the legislative requirements. If we were in a situation where where this proposed bill is passed as it is or in a similar form, when I'm asked the question, could we please have some type of remedy here? Here's the process that I would need to go through, and quite frankly, it gets to the public interest question. Part of my duty is to satisfy myself that I understand why company X or credit union X is looking for a variation of the interpretation of a rule, and I need to satisfy myself whether this is to serve a private interest or the particular interest of a particular stakeholder, or is this to serve the broader public interest that the legislation is intending to serve. So assuming I'm satisfied that the request is being made as a result of, for example, a public health directive that is essentially preventing folks from assembling in groups and is in conflict with the provision that says you must assemble in groups, then I would ask myself, what's the recommended least intrusive manner of altering that legislation that doesn't unduly affect the rights of the members of a credit union, for example, or minority shareholders, or members of a company or not-for-profit company. I would then tailor my recommendations to cabinet based on a rigorous analysis and recommendation of what I or my staff believe to be in the public interest. And then that is presented to cabinet for their consideration and obviously their discretion to make a decision on that basis. But I believe it's an important practical observation to note the participation of the public service in the deliberation process of what is asked of cabinet, and to also make a recommendation, which is our duty, to make a recommendation that we deem to be in the public interest after a sufficient level of due diligence.
That's all for now, Chair.
Okay.
Thank you.
Thank you, Trish. Annabelle?
Chair. So back at the beginning, you were clear about sort of the statutes and the obviously there's a list, and some, within that I counted 37 that had sort of notes from you. There obviously may be more, where there is an issue to be addressed regarding either the provision of services, benefits, or compensation, or around time limits, specific time limitations, specific periods of time, or form or manner, like as we heard about, and then including licensing and appeal priorities. Obviously we're here to ask questions, and a healthy debate includes, us asking questions that challenge perhaps what other people may feel. But this is pretty black and white. There's, the legislation requires, as I understand, a non-profit corporation that has to have its meeting within a time limitation that is the law, and it becomes a real issue. My point on that is that we are able to identify the statutes and the legislation that are immediately egregious in terms of potentially being at risk in the event that there's a crisis. And I've not been in the House, as long as some of my other colleagues here, but I've been here long enough to know that we can get through housekeeping bills in a pretty timely manner. We've done 11 in one afternoon. We don't have a tradition of omnibus bills, but we're certainly capable of doing those, the same as anybody else. At what point do we make the housekeeping aspects, at least on some of these things that we know are tripping us up, and we can see them coming, at what point do we begin to sort of bring forward housekeeping amendments to address some of these issues around the disparities of time limitation, or to provide more flexibility? Because we are in a time of crisis. It's whether we're staggering from a hurricane to a climate emergency to a pandemic to whatever, this isn't going to stop. So there is another route, which is to fix the legislation. And the longer we talk about it and don't fix the legislation, the longer the legislation remains unfixed. That's a really long way, and I apologize, Chair, but it's the context. It's how I think. I have to talk to think. It's a really long way to get to the point of saying, there is something else that we should also be doing. And is that on the radar? We've seen a lot of housekeeping stuff come forward, and this, to me, sits in some of this, at least, sits in that space.
I think what you're going to see, and I mentioned this committee of the whole, is you're going to start to see some of this legislation percolate up to the House for debate and consideration. As I noted before, and you saw from the list, there's a significant number, and that was just a sampling. That's a quick review.
Yeah.
I agree, we'd love to be able to fix, we have a lot of legislation with issues beyond COVID-19 as well that we would love to be able to fix in a timely way. But we are limited in our ability to bring these things forward promptly as well. So perhaps Steve can talk to the nonprofit piece, but I guess the short answer is we are on the job. We are trying to get legislation forward. I think you will see some of that legislation come forward, both in this session and in coming sessions, to try to deal with some of these issues. But we do need the time. Some of these issues might be simple, but we need the time to be able to do the proper policy work too, to identify what's the issue, what are the options, what are the interested stakeholders saying about it. Are there interjurisdictional implications? Those sorts of things. So we still have to do our proper work.
Absolutely.
Some of the things are simple, and I hear what you're saying. I've heard what the other members have said too. Why not bring an omnibus bill with a quick fix? The answer is, in most cases, it's not really a quick fix. From where I sit, now I'm a bit of a generalist in my position, I need to have those consultations with the operational people. And the operational people right now are full out as well, trying to keep the programs running. So we are working on it. I think you will see some of that come forward. This isn't the ideal long-term fix. Obviously, we would like to be able to bring our statutes up to the point where we're able to deal with much more diverse situations. Most of our legislation, as you would have noticed in your time in the House, is from the mid-20th century, if not earlier. And it can take some time to get through it. I think we do 20-plus bills per session typically, full debate and all the rest. I know on a typical bill, I'll put in about about 100 hours prep time before it comes here, working with other members of my team to get things here. So we are working on it, but I think this will give us the flexibility to deal with the immediate issue pending departments coming forward with the longer term solutions to deal with some of these issues. And Steve.
And if I may, Mr. Chair, I could perhaps provide some context there. Ms. Bell, to your question, which it is a very important observation. I believe that there is a policy thread here that I recognize through my interactions with members of the public that there's very likely a recognition across the country right now, not just in our government, of a need to review and update our legislation to address these types of situations, whether it's a natural disaster or in this case a pandemic. And quite frankly, my the third aspect of my answer to in my example of fielding a question from the credit union system was just that. I said I hear what you're saying, which is you need some kind of a fix to this situation. In my role, I communicated that issue and that need up through our minister of well, let's call it an acute short-term concern from folks that are looking to comply with their legislation. In one sense, we're indifferent at the operational level as to how that's addressed, but to make sure that issue is advanced, which we have, and it's probably one of the reasons why we're here today. The thing I also communicated to folks when fielding these types of questions early on was that, in my opinion, this pandemic is going to shepherd a whole suite of amendments to corporate and commercial law to allow much more flexibility, whether it's in terms of virtual meetings or these sort of form and manner requirements. Because they were not drafted with this in mind, and that within now in my practical experience, I'm predicting that that's going to happen within 24 to 36 months, that you're going to see this rolling out across the country, and left to our own devices at our pace, which can sometimes seem quite frustratingly slow, we would be looking to keep in touch with other jurisdictions, understand how different legislative fixes are being drafted, what policy considerations are being undertaken, and try to come up with a legislative amendment recommendation that's consistent with to the extent it's possible, the policy consensus across the country, and that's consistent with our understanding of modern corporate and commercial law, how it's being how it's being applied. So I believe that there are two issues at play here. There is an immediate issue of concern from folks who are perhaps experiencing legislation that is not allowing them to do what they need to do in the context of competing public health orders. But I think there's also an issue where people are forcing governments across the country to take a look at legislation and come up with long-term fixes that quite literally would just have not been designed into the legislative models that we have today.
Chair, can I just do a
Annabelle,
follow?
yeah.
Thank you. I appreciate the thoughtful answer, because obviously this is in no way a simple problem, and the complexity and the integration of the legislation with each other and with policy and so on, but also that responsiveness is something that we can't avoid. And I mean, Steve knows me from other lives, and he knows that I am not a patient woman. And this place has made me more patient, I think, than anyone would imagine. But I understand the process involved. Obviously, we've also been sort of going through the work involved in developing and bringing forward legislation, and sort of from our context have that understanding. I guess there's two parts to that. One of it is these things are not mutually exclusive. We can talk about things that we need to do on an emergency basis and on a responsive basis in terms of the context of now, and talk about and actively work towards goals of, from a prioritized approach, ideally, and I particularly get the piece around the corporate and business structures, but there are obviously services provision is a primary. And so this, with that, you know, I'd like this committee to consider hearing from you and from your teams on what additional resources you need to make that a priority. Because, you know, when I look at the capacity that we have as legislators and then all the pieces around that, we know where some of those choke points are, but I don't think that we have the luxury of doing these things 20 bills at a time, and once or twice a year. So I would really, Chair, really like to make a point of potentially that this be an action, maybe it's a motion that I put forward, that we intentionally consult and talk together about what additional resources can we provide to make this a priority, because while the rest of the world is pivoting and our legislation can't be a barrier that prevents us from being able to pivot too, right? But I would also add that, you know, I absolutely appreciate the amount of work that's involved in this and how intensive. But I recognize in what you're saying is about the level of consultation, about the level of discussion that you have on an operational basis and with stakeholders, and that won't happen if we change legislation under emergency powers. That will happen behind closed doors in Executive Council, and that due diligence and that level of expertise and thoughtful process that you bring to making changes to legislation is not going to happen that way under this current powers. So that is where my discomfort and perhaps my colleagues' discomfort comes from it, and so that's why we're here. That's why we're asking these questions, and so I recognize both of those pieces. Chair, that would be my comment. But I would like to make a motion that we do pursue looking at what, if any, additional resources or supports that the Assembly or its committees can provide to the department in terms of that review and update of legislation on a broader scale.
Just a second. So that's a motion that we'd like to make right now at this time, or do you want to wait till the...
Yeah.
Okay.
I think I don't like, it's there now. We've got it in our notes from the meeting today, Emily.
Yeah.
Perhaps the clerk could.
So I'd bring that motion, just trying to figure out when the most appropriate time was, today or later on, or the motion's on the floor, I guess.
Sure. Yes, the motion is on the floor. I have taken notes of what it was, but I'm just going to read to clarify, and if there's anything that I missed, please advise. So Hannah Bell moved that the committee pursue looking at what additional supports the Assembly and its committees can provide to the review of legislation. To provide a more timely review of legislation.
Okay, maybe now we'd offer everybody a chance to speak to the motion. I had Brad Trivers was talking. He was Brad Trivers.
Well, thank you, Chair. And in fact, my comments and questions were actually right along this same line. I think it's really important to note that we are talking about two different things. One are short-term changes that have a sunset date on them. Ones that, you know, repeatedly members from all caucuses have said they have no concerns with our Premier and our government using these powers in a nefarious manner. They're going to use them responsible. The leader of the opposition is quoted in the media saying this. And then we're talking about the short-term stuff, right? The sunset clause was supported by all caucuses. It's going to expire. Originally it was 18 to 24 months, right? They're temporary modifications. They're not fixes. So now, I mean, that's really what, to me, the scope and the purpose of this committee was. Now we're switching scopes. And now we're going to talk about the long-term fixes, which I agree need to be made, and we need to consider that for sure. I think this is something that is a task that government is always is associated with, a task that's always on government's mind, something government is always pursuing. And I think that this motion that, you know, the Legislative Assembly should support that is almost a moot point. Of course, the Legislative Assembly should support that. Of course, the committee should support that. That should be one of the main focuses of the committees, making recommendations to government and to the Legislative Assembly on what should be pursued, right? That's what the whole purpose is. I feel like we're defining one of the core purposes of the Legislative Assembly in this motion. I'm not sure we have to do that. I think we need to get back to what we're actually talking about here. We're talking about bringing in short-term, temporary modifications to address real needs. And it's really, Mr. Chair, it's really ironic because on the first day of the sitting, I believe it was, there was a unanimous motion passed that everyone in the chamber would agree to pursue, some sort of hybrid model to do a virtual sitting if we needed to, as a Legislative Assembly, to make decisions. And yet, the member across, who's actually the chair of the Rules, Regulations, Private Bills and Privileges Committee, who's championing changes in this spot, and who would be responsible for those sort of changes to the Legislative Assembly, hasn't even convened a committee to meet on those things, Mr. Chair, right? So I just find it really sort of ironic that now she's putting forward a motion that the Legislative Assembly committees should look at recommendations to change legislation to bring it up to date when that's the core function, when her committee hasn't even met to look at the actual real urgent stuff that, I think that she's championing. So it's quite confusing. I think we need to get back to focusing on what we're talking about here. We're talking about, the ability to make temporary modifications that are sunset so we can deal with the emergency right now. I think it's of course we are going to look at long-term fixes and long-term solutions. That is actually the function of the Legislative Assembly. And that's the function of government and one of the responsibilities of government as well. So I think we're getting off track here. I don't know if it's grandstanding. I don't know why we're going this direction. I think the point that I've heard, what I've taken away so far from this presentation, is that there is a ton of legislation with hundreds and hundreds and hundreds of hours to change to do it properly. And what was actually put forward in Bill 37 was a temporary change with a sunset clause so we can deal with it in the short term. And Mr. Speaker, I should say, Mr. Chair, I feel like talking to Mr. Speaker. I mean, the other member across, Ms. Altas, I can go back to the standing committee meeting from September 25th, and I can quote, I think we need to recognize that having the EMO and Premier and the Minister come and speak to this committee is not the final step. It's not even close to actually making any changes that would need to happen as a result of what we learned from this. Of course, this was in the context of Dorian, but I continue to quote, I think that having them come in as soon as possible to discuss things are ongoing and that the public would need to have a better understanding of, such as the disaster relief program, but also any other learnings that have already come from this experience, that we need to act on immediately in case we do face another crisis, and that could happen at any point. We just need to be prepared. Sometimes things take a long time, and we have a fall sitting coming up. If there are things that need to be brought forward there or could be brought forward, any changes that need to be made at that level, I think we should have those discussions sooner rather than later. That would not, of course, preclude the Minister and the EMO coming in after a more complete review is conducted. So she is essentially saying the exact same thing we're talking about here. Her arguments were with Dorian, but Bill 37 is trying to immediately address short-term temporary modifications that have to take place so that we can keep islanders safe and we can continue to do the job of government. There's a sunset clause. Opposition has read all caucuses.
So we're just going to speak to the motion.
Yeah.
Just make sure you're staying on.
So this motion is fundamental. It's coming back to the core reason the Legislative Assembly committees even exist. And so Chair, I think when it comes down to it, we need to, as you say, we need to start focusing on why Bill 37 needs to be passed and should be passed, and we need to get out of this committee and get back to the Legislative Assembly so it can be passed, so that we can continue to do the work of government. And in the long term, let's focus on the long term the way we always do. So I think this motion is moot. It's is almost irrelevant. I think it's the work that has always been done, will always be done, and I don't support the motion.
Chair, can I have an intervention? Just
And-
since
and
I
you-
was directly,
Okay, well, I'll allow it for this time.
thank you, I'll try to be brief. Thank you for quoting me, Minister, and thank you for paying so much close attention to what I say, I appreciate that. I had never suggested that we change or circumvent the process, and most importantly, to take away any power from the Legislative Assembly to do its job, which is to, have overview and to hold government to account. That was never part of what I intended, and you can go back again to that quote and you can see that that's not what I said. But, I wanted to point out that this whole meeting is taking a strange turn, and we're here to ask questions. That's why we put this, the motion forward. Sorry, the motion to bring this to committee, that it was brought forward so that we could ask questions. This is a very important bill that government has put forward with very serious shift in who would have authority to make decisions and how those decisions would be made. So we're going through this process so we can have those questions answered. To be perfectly honest, what I'm hearing from both ministers over there is not making me feel any more confident about that we should be supporting this bill, because any intention to stop the process of asking good questions, which is why we're here, is, I think, misguided. So I will just ask that you...
I'm just debating the motion.
You're debating the motion by quoting me
Trish
from
Altes?
a committee in September that we're perverting my words. I don't think that's appropriate. I will just leave it there, Chair. Thank you.
Thank you very much. Thank you. Jamie Fox?
Thanks, Chair. First of all, I take offense to your accusation there a minute ago. And I want that noted. Is all I'm telling you is an example of how we had an act that was prepared to deal with situations. That's all I went and said. And I also pointed the fact that how the public sector works and how emergency responders have to deal with stuff. So if you take offense to me pointing out who all this affects, then I don't appreciate that. The motion that we're debating on the floor, or pardon me, this motion we're here for this committee, is very well laid out by the Legislative Assembly. Therefore, be it further resolved that the committee invite representatives from each department of the provincial government to present on how the circumstances of COVID-19 have affected and are affecting the department in question, and how the proposed powers would affect the department in question, or the circumstances under the use of the powers might be represented by the department. Our mandate and our scope is very well laid out, and I think that the motion that's put on the floor by the honourable member takes us outside the scope. I am not in support of the motion. I am support in debating what the Legislative Assembly put us here in this chamber to do, and that was look at COVID-19 and the emergency measure bill on the floor. With that, I am not supporting the motion by the honourable member.
Annabelle?
Thank you. The motion, the original motion that referred to this bill was actually written by the official opposition, so thank you for the confirming that it was well put together. Absolutely, it has very clear scope. I would point out, however, that it is not predetermined that this bill will actually pass through the committee with a recommendation of approval. This is part of this discussion, and this debate was moving the bill from the floor of the committee of the whole into this committee so that this further discussions, including discussing with representatives from the departments, could happen so that we could decide whether or not we were going to recommend on the bill itself. So it is not predetermined that the bill is actually going to pass if and when it returns to the floor. That's the point. And then, so by context, Chair, and obviously, we have many other ways that we can provide support and above and beyond what is currently available to the key functions of government, not only in committee, but part of that is in the event that this bill does not pass in its current form, we need to also have a backup plan for that. whether that be that new legislation needs to come forward that kind of looks at the same kind of measures again, but in a different format, whether we make significant amendments to the bill so it looks different when it comes back to the floor, or if it doesn't come back forward at all, what are we then going to do? And so that is the context, Chair, for me speaking about how this fits into the broader scope of not just where we are now. We've heard quite a lot about what if there is a pandemic and that's what I'm thinking about and talking about. Unfortunately, the Minister Fox wasn't in the room when I gave that context, which was that we are in a new normal of things not being normal, and that all legislation will eventually need to be reviewed and updated accordingly. So it's unfortunate that he missed that. But Chair, if we don't do that with this motion, we have other means to do that again. However, I do think the context was important. Thank you for the time, Chair.
Thank you very much. So we might get Emily to read the motion if anybody else would like to comment on that. Trish Altez?
I just wanted to ask or propose maybe, I don't know if anybody has any more questions for our guests here today, but maybe we can, if not, we can let them go and so they don't have to continue to sit here.
Well, we could do that. I am the chair. Thank you very much, honorable member. Yes, and the motion came up right after we were still in questions. So, I would just like to thank our guests, and two, this is going to be a very fluid week for this committee, as you can see. I appreciate they did an amazing job of coming in and doing their part very quickly. I think that our guests only had about 18 hours notice for this, so the committee would thank you for, and on a Friday, beautiful Friday afternoon. We really appreciate that, and we might ask that as we get going through the course of the week, your department is very, very important. Your section is very, very important. If we do have questions, we might ask them in a written format to you, and potentially at the end of the week bring you back in if we do have any other questions, or if that's okay to stay on notice for the week. And saying that, I'd like to thank you for your time today. Yeah. So what we'll do is we'll take a 2-minute break and we'll come back and vote on the motion and debate. Thank you very much. All right.
I have to consider how I'm going to vote.
We're back in today, and so we will be talking further about the motion that is on the floor. We still have maybe a few minutes for debate before we vote, or if you would like to vote right now, it's up to the committee. But maybe we'll get Emily to read the motion just one more time to see what is on the floor at the moment.
Thank you, Mr. Chair. The motion was moved by Member Hannah Bell that the committee pursue looking at what additional supports the Assembly and its committees can provide for a more timely review of legislation.
Perfect. So that's the motion as it stands. Does anybody would like to speak further to that? Excuse me. Okay. At this time, we'll vote for that motion. All in favor of that motion, say aye. Aye. All opposed, say nay. 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 Okay. So at this time, the chair makes the decision, and I appreciate. I think this might be the first time the chair has broken a tie in this last little while, and I think it's a good opportunity. There was incredible arguments going on each side of this, and we're here for this week to figure out how we can best follow along with what was in front of us, and how we can suggest things back at the floor of the legislature, but also how we can deal with COVID in general. I think both sides had a very good argument, but I'm going to vote yay in favor of the motion, because I think it would only help strengthen us as we move forward. So that's my ruling. Yes.
So what is the timeline we have in this committee?
Very good question. So we started yesterday. We have another, Emily will answer that question.
Thank you, Mr. Chair. So the motion, number 75, was passed on Tuesday evening. It provided a 14-day deadline to report to the Legislative Assembly. So that deadline to report is Tuesday, June 30th. And I can go over the schedule of the committee for the next week if that would be, if the committee would like that. Sure. So as the motion outlines, this committee is supposed to hear from each government department. And so we have meetings scheduled on Monday, Tuesday morning, and Thursday morning. And we have start time on Monday of 9 a.m. We have 6 departments scheduled to appear that day in 6 hours of committee meetings. So each department will be starting every hour on the hour with a 1-hour break for lunch. So 9 until 12, 1 until 4. Tuesday morning, June 23rd, beginning at 9, going until noon with 3 departments. And on Thursday, June 25th, beginning at 9 a.m., we have it's the Executive Council office at that point. So we have 1 group scheduled for Thursday. If we, need some additional time, we have a little bit of flex on Thursday morning, or the committee can also begin considering its report. And then we also have some times that can be blocked off for consideration of the report Thursday between the supper break, Friday afternoon, and then following Monday. But we can wait and see how things move along next week before we decide at what point the committee would like to meet to discuss its report.
That's Jamie Fox.
So if I understand this motion that was now accepted, now we have to go back to the departments and ask them to bring back further information on that's what you're asking?
Annabelle?
Thank you. It can just be in the recommendation in the report. It's one of the outcomes it's one of the things we're hearing that we need to do as part of the discussion that's happening with the representatives on the
Jamie
floor.
Fox. Oh, sorry. Annabelle's on the floor.
I'm trying to understand how the department's going to know what resources they need to look at every act.
Well, it's future,
Yeah, excuse me, that's to talk to the chair. Annabelle
Sorry.
on the floor.
Yeah.
And then we'll,
yeah.
perfect.
Yeah, I mean, unfortunately, you said you missed some of the conversation, Minister, because you weren't in the room, but I was speaking to the fact that as they develop their agenda of work that they need to do, that it takes a very long time for those recommendations to come forward a batch at a time. And so the question was, if you had additional resources, they don't know what they need to do right now, but one of the recommendations this committee can make in our report is that they gather that information and report back and let us know what they need so that we can then discuss at a future time, whether it's in this committee or on the floor, what additional resources they may need. It's recognizing that we need to do the future work in a more accelerated way. And we're not going to get everything done in 2 weeks. But they need to be given the space to let us know what that future work may be, rather than continuing to follow their current timelines, which are as and when it gets fitted in on a housekeeping basis.
Jamie Fox.
I'm confused. Because what I'm trying to understand here is, as each department comes in over the next 5 or 6 days, and they give us a briefing on what legislation they feel needs to be changed to address situations like COVID-19, we're now asking my department, or whoever's department, to tell us also, well, while you're doing that analysis, also you got to figure out how much resources are you going to need to do that for the future. So are we talking about creating new positions within the public sector to do this?
We don't have the power to do that within the
Annabelle?
Minister, we don't have
Power to do that within this committee. The committee has the power to make recommendations. We are currently working on the motion that referred this, and we have the scope of the motion on the floor that we're working on, which is to call those departments in. But we have the capacity to which was my intent with that motion, and again we voted on it, so I assumed you understood it. Was that maybe it would be better phrased as a recommendation of this committee back to the House when we make our report. We are not compelling that work in addition to the work that's already happening. because that scope is already there. This is a motion to ensure that we have something formal that says there's a recommendation from this committee when that report goes back that says that committees should be, or that departments should be encouraged to identify what additional resources they may need to accelerate the legislative agenda.
Jamie Foxx?
No.
No. Brad Trivers?
Yeah, I was just wondering if you could repeat that, the motion that was passed again, just to make sure that, I want to write it down.
Yeah, I can, sorry, Chair.
Certainly.
I can send around to everybody after the meeting what the motion was, but I'll repeat it for us now. That the committee pursue looking at what additional supports the Assembly and its committees can provide to a more timely review of legislation, which was carried, and I'm going to send that to the committee at this point.
Yeah, and if I may, therefore be it further resolved that the committee consider proposed and potential amendments to Bill 37 and make any recommendations that the committee considered appropriate. So it's in the scope of what we're talking about at the moment. So, and that's what I think we have legal here and justice here. This, I do believe, came out of their conversation as listening to their needs. So if you would like to we can further discuss it at this time, but I think that, I think that we can maybe just, yes, Jamie Foxx?
Emily, can you read the motion again, as passed?
That the committee pursue looking at what additional supports the...
So, thanks, right there, Chair. The committee look at pursuing.
And continue on, because you have to fill the little sentence.
Okay, so the complete motion is that the committee pursue looking at what additional supports the Assembly and its committees can provide to a more timely review of legislation.
So the question, how are we going to do that?
Trish?
So there's no timeline on that motion. It's not by the end of this 14 days. It's part of the recommendations that we can give at the end of the 14 days for what we need to do as a committee moving forward is engage with these departments and solicit this information so that we can figure out how they can best be supported, is my understanding of what the motion was, essentially. It's not they have to provide us with all of that information in 14 days, well, less now.
Yeah.
Is that fair to say? Yeah.
Jamie
So-
Foxx?
I understand what you're trying to do here, but the motion is tied to what we're here for. So automatically, the motion is tied to these proceedings.
Yeah.
And this session, or why this committee was formed to deal with this matter.
And I do believe there's a certain, when we do our presentation in 14 days to the committee, we will add that. I think the scope of what we have, I don't think we're going to be dealing with that now. It will be a recommendation that's included in therein. But it's open for, yes, Brad?
And just, I mean, we've already voted on the motion, but,
Yeah.
I mean, I think the motion's way out of order. It's way beyond the scope of our committee. If you look at what we passed, is we're making a recommendation to the Legislative Assembly as a whole and all its committees. We don't have the mandate for that. Perhaps the Rules Committee, that the members of the chair of could do that, sort of like, I don't know, I would like to ask the clerk to even review if this motion can even stand, given the mandate of our committee here. This is Health and Social Development. I mean, this is something way above beyond that. Anyway.
So somewhat, when we look at this, when we look at the bill, this is to deal with emergency measures. This is where all this is coming out. So it is under the committee's scope. It might include other committees, but we might be able to get a ruling from the clerk or your office on that.
I'll bring something back to the committee chair.
Yeah, that would be ideal. Thank you very much. Any further discussion at this time? No. So moving on with the agenda, we're going to move on to number 4, if that's okay. I do believe so. An update on public consultation. This should be really quickly. Emily will just pass to the floor for 2 minutes. So could you give us an update on that, please?
Thank you, Chair. I just wanted to update the committee very quickly on the public consultation piece. There's a lot of great decisions made yesterday, and we have been able to implement most all of them, and there are a couple pieces that we're currently working on that we'll be working on to have done as soon as possible. So in relation to the public consultation piece, we have created a webpage on our website that outlines the review of Bill number 37. It includes links to the motion, to the bill, and to the amendments that have been proposed in the House, in Committee of the Whole House at this time. Our advertisements kind of direct everyone back to our website. And so we let people know how they can provide input. There will be a feedback form, which is not ready at this point, but it should be coming soon, and we indicate that on the website. Members of the public can send an email, they can deliver to the offices here, or they can fax. We also indicate that the public deadline is next Thursday, June 25th at 4 p.m. We do note that written submissions are posted to our website, but that individuals may request that their name is not posted to the website. And so I've talked with our website administrator here, and we are able to post all the written submissions that we receive on the website, and we are going to do so in the same format that the government website does. So they post all the submissions, and what we will do as they come in, I will number them, and that's how we'll post. As discussed the other day, I will make sure that daily I send to committee members the written submissions that we receive. For posting to the website, we will be trying to do so as soon as possible. It will just depend on how much demand there is. So if we get a lot of feedback, we'll have to take our time posting, but everything will be posted to the website. In relation to the advertisements, we have posted on our social media pages, so our Facebook and Twitter, if you would like to share. We also are having advertisements in the daily and weekly papers, so we couldn't make the deadline for Saturday's paper, but in the Guardian and the Journal on Monday, we will have an advertisement, and on Wednesday, we'll have an advertisement in Lavoie and the Eastern and Western Graphic. I think that covers everything. I discussed the scheduling earlier. So I think that covers everything in relation to the public consultation piece. We also had a press release that was circulated to committee members earlier today, and if that's ready to go, we will send that out as soon as possible.
Thank you. We have Brad and then Hannah. Brad Travers?
I just wondered, have you received any feedback yet? Or any submissions?
Emily?
Thank you. So we posted to Facebook and Twitter today around noon, and our website went live today. So I haven't received anything back yet.
Okay.
I gave you one.
But I will circulate to the committee anytime we get anything back from.
Just curious.
Yeah, perfect. Annabelle?
Yeah, it's just a quick question on whether, if anybody who wanted to come to speak to the committee that was not a member of government, was that in scope? Because I'm sorry, I wasn't at the initial planning meeting, so I may have missed that conversation.
So if I do receive any such requests, I will bring them immediately to the committee so that you can consider the request and how we would. There is some flexible time next week in the schedule towards the end of the week. So if I get that request, it will go to committee as soon as possible. And we're meeting pretty regularly next week, so we'll be able to kind of discuss and deal with it when it comes up.
Excellent. Okay, perfect.
Great, thank you.
Thank you very much. And at this time, we'll move on from that. Again, the staff here has done an incredible job under very, very difficult circumstances. So, number 5, new business relating to motion 75. Does anybody have any such business? Perfect. So I will call for a motion to adjourn.
So moved.
Annabelle? Thank you.